Welcome back, landlords. Today we're talking about transferring title to your property to your tenant. It happens a lot. A landlord is sometimes just ready to be out of the landlord gig, or a landlord figures, hey, I can make a profit off of this transaction. And also, landlords sometimes really like their tenants, and so they figure, why not do a favor for this really great tenant? Well, today we're going to talk about the reasons why you may want to reconsider this particular transaction. Welcome to my YouTube channel. I've been helping clients for over a decade, and now I'm coming straight to you. To get even more great videos, click our links to like and subscribe. Stay in touch by phone, text, email, or on our highly interactive Facebook group, Texas Landlords. And now, Ernie talks. So you've decided to sell your property. You've got lots of options, and not every transaction looks exactly the same. You could do the old-fashioned cash for a title. That's easy. The transaction is quick and simple. Sometimes that buyer is your tenant. And you may find that selling the rental property to the tenant who's living there works out very nicely for you. However, not every landlord handles this transaction the same way. In fact, many landlords kind of back themselves into a corner with this transaction because their paperwork limits their rights. So today we're going to talk about the multiple ways that you can transfer your title to your tenant if that's your decision. So option number one is the most straightforward option. That is cash for the deed. Your tenant says, I really love this place. And you say, really? Well, here's what I'll sell it to you for. And that number, whatever it happens to be, is the agreed upon price, just like you would sell it to any other person up on the open market, except you've got one shopper here. And you may decide that this option works best for you, and the tenant may decide that this works best for them because they've just been there for so long and they love the place so much. And so this transaction works. You might decide to employ a title company for the benefit of the buyer in this case, but you really don't have to. All you have to do is sign a deed from you to the buyer. You can have a formal contract, but you don't need it. If you choose this informal process, you can transfer your ownership directly to the tenant, and you're done in terms of your obligations to the property, in terms of repair, in terms of any taxes or homeowners association fees. All of that transfers, and the responsibilities all transfer to the tenant when you transfer your title to the property. But that's not always the way that these transactions work. Sometimes there's financing involved, or the tenant is unable to obtain financing, and that might be what's delayed them or kept them as a renter for this length of time. You may be presented with an offer to purchase, but not with an upfront payment. Okay, that looks in a number of different ways. So, for example, your tenant might, at the time that you sign your lease, desire an option to buy. So what does this look like? Well, your lease may have an extra portion added to the end, an option that the tenant should purchase. This should not come for free, right? Because the option to buy always exists. But if you put it in your lease, you're probably establishing, number one, the property address, and number two, a set price. If you're doing this and you plan to lock in a price, recognize that you're excluding everybody else, including people who would be willing to pay higher than that price, sometimes multiples of that price in certain situations. But it's an option that you have, and you can give your tenant an option to buy. But again, my recommendation is that they purchase that option. And so, based on what you believe is a fair market value for the property, you can lock in a certain rate and say, look, you're going to rent this place for 6 months or 12 months or 18 months or whatever. And during that entire time, so long as you don't breach this agreement, I'll agree to sell this property to you for X number of dollars. And so your tenant can lock in a set price, and you can also lock in a set price should the tenant ever decide that they want to buy the house. So why would you do something like this? Well, it might be an incentive to a tenant who's kind of on the fence with leasing the property. And so you may have discussed the option to buy, and so maybe that gets them over the line, and they decide, definitely I'm gonna rent this house, and should the situation allow, I will purchase it at this agreed price. Again, because you've locked it in, you can't offer to sell the house to anybody else. They get a right of first refusal during the term of their lease. And if you violate that, you can find yourself in court fighting over who has the right of ownership. So if you don't intend to lock in the price, don't do this. So your next option is to sell your property to your client through some kind of owner financing, right? In this way, you kind of act like a bank, and you basically need 3 documents in order to get this done correctly. I've seen clients do this with 1. I've seen clients attempt to do this with no writing, but you can't do that. You can't transfer property, real property, that's the land, the house. You can't transfer title to real property without something in writing in the state of Texas, and really anywhere in the United States. You need some basic writing. I don't recommend going basic, but if you're going to establish owner financing, you need something even more than just the original agreement to sell the property. You need the deed transferring title from you to them. You need a promissory note, which is the buyer's agreement to pay you in some kind of regular, usually monthly payment at some agreed amount for some, and also at an agreed interest rate. Which could be 0, but certainly can't be so high that it violates the Texas Finance Code and causes you problems. The third is a deed of trust, which is essentially the establishment of your lien on the property, so that if in fact the buyer defaults, you can step in very much like the bank and issue a foreclosure. Now, I mention this because although you get all of the rights of a bank who loans money for the purchase of real property and maintains a lien, that's your deed of trust, you also have all of the duties and the obligations of a bank, including the issues of financing and staying within the parameters that are allowed by the finance code. What you don't have is an absolute right for possession in the event of a default. And too many landlords turned sellers get this part wrong. And so here's the common scenario. Former landlord decides, I'm going to sell my property by owner financing to my former tenant. I use the term former on purpose because once you have transferred title, even if it's not recorded, but once you have transferred title over to your former tenant, they're no longer a tenant. Now they are the owner of the property. And even though you maintain a lien with your deed of trust, that doesn't mean that you get to evict anybody. You are a few steps ahead of yourself if you begin the eviction process because someone has defaulted on their promissory note. You just can't do that. If you go into eviction court, the tenant that you call in your petition will show up and say, nope, I am a buyer look, I've got a deed. And the judge cannot grant an eviction in this case because this is not a landlord-tenant situation anymore. Once you transfer title, even if it's not recorded, once you transfer anything that gives ownership, you can't evict. Now, if you do find yourself in a default in an owner financing agreement and you have sent all of the requisite notices to the buyer, you can, with proper posting and proper procedure, foreclose your interest on this piece of property and recover ownership. At that point, the buyer becomes what we refer to in the law as a tenant at sufferance. And so there is a tenancy, there's no rent and no rent agreement between you both. But at that point, once you have gone through and retaken title through the foreclosure process, you at that point can file an eviction and you can recover possession. Before foreclosure, you don't have that power. And too many times, landlords who decide they're going to sell by owner financing jump the gun and attempt to evict and then are disappointed and they come to me and say, I don't know what happened. The judge got it wrong. The judge doesn't know the law. Not true. And so if you have sold your property by way of an owner finance agreement, you cannot evict until after you have foreclosed. If you're in the middle of a default of some sort, you need to talk to an experienced real estate attorney to figure out what steps you need to take if you're interested in possibly a foreclosure or possibly recovering your property or working out some kind of settlement agreement with the buyer, who can even hand over title back to you. But unless that process happens, you're not the title holder and you're not able to evict. So the last option that I want to talk to you about is called selling your property by a contract for deed. I do not recommend this method. People still do it. It used to be much more popular in the past, but the law has changed and courts crack down on this particular transaction because it's hard to get right. And here's what it looks like. It's kind of a rent to own scenario. You have a lease and you have an agreement for purchase behind that lease. And what that agreement for purchase says is, well, if you as the tenant maintain this contract and all of your payments all the way to a date X, or you've paid amount Y, I will at that future point transfer the title. And in a lot of ways, this makes some kind of sense. We do that with our automobiles, right? We go and purchase our automobile and sign a note, but we don't get a clear title until sometime later. But we do get title. We do get ownership of that vehicle when we sign our promise to pay it. Well, a contract for deed delays that issuance of title. Chapter 5 of the Texas Property Code protects the buyer. After 4 years or 40% of the agreed purchase price has been paid, that buyer can now demand a deed, a note, and a deed of trust. So if that's the case, why not just start off with it? Why not establish your rights from the beginning? Well, some people like the contract for deed. It gives a lot of power to the seller, who actually maintains landlord language in their agreement. Who it works out terrible for is the buyer, except that Chapter 5 of the Property Code has a lot of teeth to it. There are yearly disclosures that have to be given, and if they're not given, that buyer can sue the seller and can ask the court for all sorts of judicial statutory remedies that are available in Chapter 5. What Chapter 5 does is creates a situation for a landlord to ruin an otherwise valid transaction. My suggestion is to stay away from a contract for deed. It has too many pitfalls, it has too many penalties, it has too many things to get wrong. If you want to sell your property and you want to owner finance and you want to, step in like a bank would, you can do that. But my preference always when you're selling property is just to sell it outright. If you sell it and recover all of the profit up front, you don't have to worry about things like foreclosure or Chapter 5 of the Texas Property Code, or collecting monthly payments and sending notices of default or notices of acceleration. All of that's gone. Now, some people prefer this avenue. Some people prefer the owner financing because they've done it for years and they're good at it, or they've done it for years and they find it profitable. And it can be, right? So imagine a situation where a seller is selling the same piece of property over and over and over again, taking a large upfront down payment, selling to people who ultimately default, and then following through with all of the requirements of the Texas Property Code for foreclosure, and then recovering ownership of that property just to sell it again. It can be profitable. However, it can also be risky. And so with every possibility of profit comes the possibility of risk. What happens if one of the defaulting buyers files for bankruptcy? Bankruptcy could tie up your property for years. And if your buyer files for bankruptcy, your profit margin might get eaten up by legal costs associated with that bankruptcy. There might be the possibility of a higher return, but the risks are also higher. And so you decide what transaction works best for you. If you're a landlord who decides you want to sell property, you've got options. And so you've heard me talk about numerous options that you have. My least favorites are the contract for deed and the contract with an option to buy. They both have issues that can come back and bite you. Owner financing has its risks, but it also potentially could have a high reward. The cleanest transaction is a straight up sale. You show up to closing, you hand over the keys and the title, and you're done. You walk away with your profit up front and can use that to invest in future property. Landlords, I hope this was helpful, and maybe I've changed your mind or convinced you to stay in the landlord gig. Whichever you decide, I always wish you the best of luck. And in any case, happy leasing. If you enjoyed this video, we invite you to like and subscribe. Follow our links to even more great content. We're always adding to this collection. If you have a video topic you'd like to see, comment below.